morning to everyone. So I think we can start, although it was quite challenging to reach the room in this new beautiful venue. And I want to thank you to be here. And our panel is focused on the interplay between the Brazilian and the European regulation with a focus on AI regulation. You know, CPDP traditionally focused on data protection, but the field of data protection is broader and consider also the impact on AI. All the experts and scholars seems to be very interested also in AI and AI regulation. For this reason, now is CPDP.ai. So this is an evolution. I'm very in favor of this, including the fact that the Data Protection Authority should be the authority that have to supervise AI, but there are many different opinions on that, and so it's something for discussion. Today, our panel was organized based on the fact that there is an interesting process in Brazil in terms of shaping a future regulation on AI that to some extent is a parallel process considering what is happening in Europe with the AI Act. There are similarities and there are differences, and also is an element that can be used in order to provide an interpretation to the global dimension of the regulation of digital society. So for this reason, today we have 4 speakers. One will arrive a bit later, but we have on my left Miriam Wimmer. Miriam is an academic, but she is also director of the Brazilian Data Protection Authority. Then we have Nicolò Zingales, FGV Rio, Center for Tech and Society. Nicolò is a typical bridge between Europe and Brazil because he has extensive career in Europe and then he moved to Rio. And then we have Mariana Rielle from Data Privacy Brazil. Data Privacy Brazil is very active in São Paulo, and has supported many activities also in terms of capacity building and in terms of civil society and advocacy with regard to privacy, and also now is very involved in the AI regulation and the we can say participatory approach in shaping this kind of regulation. And then will come Laura Schell-Mendez from Goethe University, but she's also professor at EDP in Brasilia. And so we have a panel that is a mix of European and former European and Brazilian colleagues. So I think that we can start this discussion. And so I'll give the floor to Miriam for our introductory remarks.
Okay. I think this one's better. Okay, good morning, everyone. I'd like to begin by thanking Professor Alessandro for the kind introduction and also for the invitation to take part in this panel. And I think as opening remarks, it's interesting to set the stage a bit and explain what Brazil has been doing in terms of AI and how this relates to data protection. So it's important to note that this discussion on regulating AI in Brazil is not something new. In fact, for some years now, Brazil has been carrying out efforts to better understand this technology and to introduce it in terms of public policies. So for instance, in 2019, Brazil was one of the non-OECD countries that subscribed to the OECD AI principles. In 2020, Brazil formally approved, or 2021, its national AI strategy outlining its vision and priorities for the responsible development of this technology. And in 2020, so 4 years ago, a bill of law was introduced in the National Congress and the Chamber of Deputies proposing regulation for AI. So it's important to note that this is a discussion going on for some time now. And this initial bill, called Bill number 21 of 2020, was a bill that had a very high level, very principle-based structure. So a very short bill, strongly based on the OECD principles that essentially did not really attempt to regulate AI, rather the opposite. So it was a deregulation bill in the sense that it only proposed very high-level principles and placed lots of emphasis on the possibility of private sector self-regulation. This bill was very quickly approved in the Chamber of Deputies, and as a sort of reaction, when the bill then went to the National Senate, there was a feeling that more discussion was needed in order to depthen the discussions and better understand what the best approach in terms of regulating AI would be for Brazil. And so the Senate promoted the creation of a committee of legal experts, a committee of jurists, that was headed by Minister Cueva from the Brazilian Superior Court of Justice, and Professor Laura, who will be joining us shortly, was the rapporteur for this committee. And this committee, in fact, worked during approximately 1 year with a strong emphasis on social participation. So there were many, many public hearings with over 50 experts, Brazilians and also international experts, over 30 hours of recorded discussions, 102 written contributions, international seminars, benchmarking covering 31 countries. This was, in fact, a very in-depth work. And as a result, a new bill was proposed by this committee of legal experts that in many ways, in fact, resembles the European AI Act. So it's a bill that seeks to adopt, of course, a risk-based approach, but also a human rights approach. And this is perhaps one of the most important differences in both bills. So Brazil has a very long-standing tradition of discussing digital rights. We have a famous law called Marco Civil da Internet, which is a civil rights-based legal framework for the internet. So we have, I think, over a decade of a tradition of discussing digital rights in Brazil. And as a result, when the Brazilian AI bill was proposed, there was a whole chapter focusing on fundamental rights, building on these principles that have already been internationally agreed. So the idea of a right to explanation, the right to human intervention or human revision, the right to correct discriminatory biases, and so on. I think Mariana is going to talk about this in more detail. And the bill also establishes certain governance mechanisms that organizations developing or deploying AI need to adopt, with additional requirements for high-risk uses. So in a manner similar to the European AI Act, there is a classification of high risk, medium risk, and low risk, and the obligations are proportional to the level of risks. I think a topic that is important to discuss, and this is particularly the take I would like to present in these opening remarks, is the issue of the supervisory authority. So Alessandro already gave his opinion that DPAs should in fact be in charge of this discussion. And in Brazil, the bill also proposes the creation or the designation of a responsible agency or authority responsible for implementing the bill, for giving consistency, coherence. And this is in fact one of the most interesting discussions in Brazil at this time, because in Brazil, as also in Europe, it's very clear that AI produces impacts over all economic sectors. So there's a very complex institutional setup where, on one hand, we discuss the need for a centralized authority able to interpret the law in a coherent manner. But on the other hand, we have to recognize that there are sectoral specificities. So for instance, in the telecom sector, the financial sector, the health sector, there are specific rules, and there are also specific regulatory agencies. So for some time in Brazil, there was a sort of polarized discussion between the idea that we should either have a centralized authority or we should have a decentralized approach by which all of these sector-specific agencies would be responsible for regulating and implementing the bill within their own field of expertise. This discussion is not yet resolved because the discussion is still in Congress, but the most recent version of the bill, in fact, provides for a sort of hybrid approach whereby there would be the creation of a system with a centralized authority responsible for coordinating efforts to enforce the legislation throughout different sectors, and thereby providing consistency, coherence, and a harmonized interpretation throughout this very cross-cutting legislation. And I think one of the most important issues is who then is going to be the supervisory authority. So also in Brazil, different proposals have been put on the table. Initially, some stakeholders were in favor of creating a brand new authority. This is a beautiful idea, but in fact, it's not really very feasible because, of course, there are budgetary consequences, but also it takes time to create new authorities. So if we're dealing with a topic that has a certain urgency, that has immediate impacts, creating a new authority would mean that the effectiveness of the legislation would be postponed for, let's say, 2 to 3 years, which is certainly not ideal. 2 to 3 years at the most optimistic outlook. So other discussions were initiated, and I think that at this point in time, there is a certain level of understanding that the Data Protection Authority would be best positioned to take on this role of being a centralized authority in coordination with different regulatory agencies and governmental bodies. And this understanding, I think, comes from the perception that there is, of course, a very, very strong interface between artificial intelligence and personal data protection. Not only because AI depends on large volumes of data to be trained and to work and so on, but also because our general data protection law in Brazil, which also has many similarities to the European GDPR, already provides for a number of rights that are very close to those discussed in the AI bill. So, for instance, the right to request the revision of automated decisions, the right to an explanation, the right to have access to data, and transparency rights in general, the right to oppose automated decisions, to challenge these decisions. And these items are, in fact, already part of the National Data Protection Authority's regulatory agenda. The DPA has, in fact, explicitly included the issue of AI in its priorities for 2021 to 2023. And the DPA has, in fact, also begun working on a regulatory sandbox for AI, specifically seeking to investigate the issue of machine learning technologies and how they could better interact with this idea of a right to an explanation or the right to challenge automated decisions. So, in fact, this is still an open discussion. As I guess in many countries, there is not yet a final decision. But just to give a brief overview, this is perhaps where the debate stands at this point in time in Brazil.
Thank you, Miriam. Thank you to provide us this overview about the AI regulation and also touching the point of interplay between AI and data protection that is consistent not just on the topic of the conference, but is the main issue in terms of regulatory organization, we can say. So I give the floor to Niccolo for... I have it. Oh, I have this one. Perfect.
I think it works, yes. Hello, good morning. So it's a pleasure to make the bridge between Brazil and Europe. So as Alessandro said, I was an academic in Europe until right before the pandemic, and then I moved to Brazil. I was following already, the proposals to regulate AI, and I must say it's been difficult to keep track of all the changes of the text, the last version of which was approved, I think, last week. But at the same time, this process was developed in Brazil. I think it was remarkably in a very participatory manner, as Miriam said. And not only there were the hearings, but also submissions made by civil society, academia. It was a pleasure to participate in that. And then we saw the inputs being taken into account in making this second bill, draft bill, that substituted this initial principle-based regulation that, in fact, was more about deregulation than creating a lot of new obligations. In fact, so why do we say deregulation? Because there were already provisions, primarily in the data protection systems applicable to AI, but they were lacking some teeth or specificity, let's say, to make those rights more effective. Some other provisions were also included in the Marco Civil, the Internet law, and also the consumer protection legislation. But there were general transparency obligations about the products being put on the market, their characteristics, and they did not have to deal specifically with automated decisions. There was an emphasis in the data protection bill on automated decisions, but the law that came into force did not follow the suggestion to include a human revision of the automated decisions, as was the case in the European Union. So eventually, what we were left with in Article 20 of the LGPD was that one would have the right to request a revision of automated decisions. And this could be done also on an automated basis, so you could simply remake the same decision. But then there was a possibility to call the Data Protection Authority in case the information that was provided was not enough. And then you could ask the Data Protection Authority to make an auditing with a view to addressing the discriminatory aspects of these automated decisions. So the new bill improves significantly this scenario. Now there are rights to, as Miriam said, to an explanation, to human intervention, so much more effectively dealing with this problem. And also, I think something that we were missing in the data protection legislation, even in Europe, is what kind of decisions are considered to have a significant impact on the data subject. And here the bill innovates by creating 3 categories of decisions that are considered to be presumptively impacting the data subject, which is when the decision is irreversible, when it is a high-risk AI based on profiling, and then when it creates a risk to physical calamity, yes. So here perhaps one footnote is that it would be interesting to also expand this last element to also more psychological harms, which is not currently there as one of the presumptions, but still this doesn't prevent the jurisprudence from recognizing this as a possible area of need to provide explanation. Then one thing that the bill does in terms of transparency is also being specific about what needs to be provided. So it's not just an explanation about the logic. It also says that you need to provide the criteria that are being used and the weighting of these criteria when appropriate. Now, of course, lawyers know that when appropriate is dangerous to be basically used and applied by the jurisprudence depending on the situation, but still, I think the fact that it refers to weighing is particularly relevant because this was absent from previous legislation, even in the European Union. On right to explanation, it's interesting also to note that the bill refers not only to an individual right to explanation, but also a group, and a group that's been harmed can request the explanation. Another aspect that the data protection bill did not, let's say, enforce yet data protection law was not enforcing very effectively is what does it mean to exercise the rights. Data subject rights is now one of the areas in which the NPD the Data Protection Authority is going to develop some guidance on how the rights can be effectively exercised. And here the bill is also promising because it says that from the start, these companies providing AI, they need to clarify how the data subject rights, how the rights provided by this law are to be enforced. So this must be disclosed ex ante, which is, I think, an improvement. Other aspects of transparency that are relevant are like in the European version, you need to clarify when you are dealing with a human that the interaction that human is having is based on AI, so that it is interacting with an AI. So this is a general right of transparency that is applicable to all types of interaction, but then also with regard to synthetic content, like deep fakes, there needs to be a disclosure that this is indeed generated, synthetic content. On the other hand, this doesn't cover, like in the last version that I was able to access of the AI Act, also the generated text. In the last version of the AI Act, I was looking yesterday, there is a reference to the deployers having to disclose that the text was generated through, say, a ChatGPT, when this is done for a purpose of informing the general public about a matter of public interest. So this is an interesting spin that is still not included in the bill at the Brazilian level. So broadly, I think you can see that the AI bill in Brazil has followed, to some extent, the patterns that we have seen developing here, but here it's been so many iterations and it has gone so fast that it has been impossible to, let's say, incorporate all the innovations that have been done most recently. On the other hand, the Brazilian version also innovates in some respects. For example, it says that the algorithmic impact assessment that will be discussed more in depth later needs to be made public for the high-risk cases. And also it says that the economic power is relevant of the providers in the duty to involve civil society when you make this impact assessment, which is something that is not explicit in the European version. Finally, just by closing this first introduction, there's an aspect in which also the European legislation first created an obligation to provide documentation on the training of particularly foundation models with regard to copyrighted material, so that it enables enforcement of copyright. Now here, this is also present in the last version of the Brazilian bill, but there are some differences. So, as you might know, in the European version, there's also the carve-out for open source models. However, to this carve-out, there is an exception when those models are high risk. And instead, in the Brazilian version, there is an exception to the need to provide extensive documentation on these models when they are transferred to another party, so they're not provided wide open, or when they are provided through an API that is closed, that is limited to basically those who are paying for the API, those within a closed system, let's say. So in this case, you don't need to provide all the sort of documentation that is the case in an open source version. So it's kind of goes in different directions. And I think this has relevance also on the type of innovation that is being encouraged. In the Brazilian version, there is also an exception to the need to pay royalties for copyright when this is done for purposes like libraries, archives, and journalism. But for other things, then you would need to be subject to the copyright rules in full. So there is different kinds of innovations that are being steered by these bills. And in the European version, the last footnote is that, as you know, it does not apply to scientific research open foundation models. So this is quite a broader exception that is not the same as we have in the Brazilian context with all these specific activities that are being identified. So it's an interesting comparison. I think this will not be the last version. We will see further changes, although the bill is supposed to be voted in June, probably. But I bet that there will be some further amendments. So that's my introduction.
Thank you, Niccolò, for these remarks, and also the focus on the part concerning, we can say, the protection and more related to the copyright use, etc. That's also at the center of the debate in Europe, and not only in Europe, also all around the world. We can say that it's another important issue compared to the issue of data protection. We can say that the two main points that raise concern is the use of data, the impact on fundamental rights, and the impact on creative works, we can say. So, welcome to Laura. She's come and joined us. I think you can continue this discussion, consider also your role in the committee that has draft part of this long process of drafting regulation in Brazil. And so I think that you can also give us some insights about the perspective, the approach, and the ongoing work. Thank you, Laura.
Thank you so much, Alessandro. Thank you also for organizing this panel and for dialoguing and discussing with us, and maybe for a year already. and helping us in this process too. So I think my colleagues explained a lot about the Brazilian bill. I would like to enter a little bit more into the details. So the bill, this bill 2338, that maybe is going to be voted in the next month. We don't know, Nicola, but maybe. It has 5 main axes. So we have principles, the guarantee of a list of rights to people affected by AI systems, the categorization of the level of risks of AI systems, governance measures and obligations, and last, an enforcement structure. And as for the first axe, the bill establishes a lot of principles, such as good faith and other 12. I'm just going to mention here some of them: human participation and supervision, non-discrimination, fairness, transparency, explainability, trustworthiness, due process of law, and non-maleficence and proportionality between the employed methods and the determined and legitimate purposes of the artificial intelligence systems. As for the second pillar, and I understand that Mariana is going to talk a little bit more about it, the draft foresees rights for people. Is it? Okay, thank you. The draft foresees rights for people affected by AI systems, which must be observed by providers and operators of the systems, and which are also enforceable by administrative and judicial authorities. So among the foreseen rights, there is like the right to receive prior information regarding interactions with AI systems, the right to explanation, the right to challenge decisions that produce legal effects, the right to human supervision, and the right to privacy and personal data protection. And the risk categorization, which makes up the third axe of the proposal, operates with 2 categories that receive differentiated treatment throughout the text: the AI systems classified as excessive risks and those classified as high risk. And the fourth axe of the bill is composed of governance measures, which constitute a set of due diligence and internal processes to be adopted by the agents that provide or operate AI systems, such as the adoption of transparency and data management measures. And the fifth pillar of the bill is about the enforcement structure. And I would like to speak here a little bit about the highlights of the bill, especially in its latest version that we are discussing now. So I would say that one of the highlights is that this supervision structure is a hybrid supervision structure, which combines a central coordination to harmonize rights with a sectorial application of the law. The bill proposes a national system for the regulation and governance of artificial intelligence, the CIA, Sistema Nacional de Regulação e Governança de Inteligência Artificial. The system would be coordinated or should be coordinated by an authority designated by the federal government. And the rapporteur, Senator Eduardo Gomes, suggested that the National Data Protection Authority could fulfill this role, but it would require stretching and expansion. The coordination authority would work alongside other Brazilian regulatory bodies, such as the Central Bank, the Competition Authority, and regulatory agencies, including Anatel, Anvisa, health regulator, telecommunications regulator, among others. I think another highlight of the Brazilian bill, and maybe it's in its core, I think Miriam talked a little bit about it, is the idea that it combines a right-based approach with a risk-based approach. So the bill establishes certain general and specific governance measures applicable to AI systems in proportion to the degree of risk they present. And maybe the last interesting point that I would like to highlight is that the bill strives to strike a balance also between fostering innovation and protecting copyright. So there are some norms regarding copyrights also in this latest version, although when we talk about compensation, it's established that we should discuss it in a sandbox So we don't have all the answers now. I think it's good for now, Alessandro, and I look forward to the debate. Thank you so much.
Thank you. Thank you for the description of the main pillars of this act. I think this is also part of the discussion in the panel and then with the audience. So I give the floor to Mariana, that also provided a perspective from the civil society in this discussion about AI. She has the slides, so if you can share, thank you.
Thank you, Professor Mantelero. Hi, everyone. Like Professor Mantelero has already introduced me, my name is Mariana, and I speak on behalf of Data Privacy Brazil. We are a civil society organization, and we have been very involved in the whole process that both Miriam and Laura have explained. And this is a very much ongoing process, so including in terms of possibilities for civil society to contribute suggestions to the text. We have deadlines coming up, and there are possibly quite a few changes that may still happen. And I'm going to talk specifically about the rights part of the rights-based and risk-based regulation approach. And I have slides. I'm sorry to break the flow of the panel, but I promise it's just a few. So basically, as Laura, Miriam, and Nicolo already mentioned, just as the EU AI Act aims to protect fundamental rights, especially because the risk that is being regulated is also, and perhaps mostly, a risk to fundamental rights. There are some differences in terms of language and the choices that the PL 2338, which is the current text, makes. So you can see that it first aims to protect fundamental rights, and then there is a mention for responsible innovation and all of the other aspects that the law also seeks to promote. And that is not just in terms of language choices, which as representative of civil society, I personally think that could be even stronger, but it is also a feature of the law because it basically seeks to calibrate, and I'm trying to kind of quote here the report from the committee that Laura reported. It seeks to calibrate the risk-based approach with corresponding rights, some of which are applicable and some of which can be exercised regardless of the risk. So this is one of the ways in which the risk-based approach and the rights-based approach are reconciled. You have a certain number of general transversal rights, mostly focused on transparency, information, that can be exercised by anyone who is affected by an AI system, regardless of risk. And then you also have some other specific rights and obligations that apply depending on the level of risk. So this is a way in which those two approaches are balanced in the proposal. And here I have, oh no, not here. Here I have a slide that shows exactly what rights we are talking about. So Article 8, we have for affected people and groups who are affected by AI systems. This is something that, as far as I know, part of European digital rights civil society asked to be included, demanded that it would be included in the EU AI Act, a section specific for affected people and groups. That did not happen. So Article 8 provides for the right to prior information about interactions with AI systems, and the parameters that it already establishes are that this information should be accessible, easy to understand, and there is also a specific and stronger provision for the hyper-vulnerable, so children, adolescents, the elderly, and people with disabilities. This can also be expanded to other vulnerable groups and individuals where the best interests of these individuals and groups should be taken into account, and transparency plus clear language should be considered. The other rights for affected people and groups, regardless of risk, is, of course, privacy and data protection, so data subject rights that are already established by other legislation, such as LGPD, the General Data Protection legislation, the right to human determination and participation in AI decisions, and of course, non-discrimination and correction of bias. This is very important. The Brazilian proposal provides for definitions of discrimination, both direct and indirect, and it takes into account also the reality of the country that the regulation is being proposed in, which is marred by structural inequalities, racism, and all kinds of discrimination. So this is very strong at the roots of the legislation. And for, like I said, in trying to reconcile the two approaches, there is also a different section of rights for, in the case of AI, with relevant legal effects or high risk. And these are the right to explanation. And I agree with Nicolo, sometimes it's hard to keep track, so I have the text here, which also includes a number of parameters for the right to an explanation that we can perhaps discuss later. But basically, the explanation must be provided free of charge and within a reasonable time frame. Also, the right to challenge decisions or predictions made by artificial intelligence systems, and the right to human supervision of decisions, which must be significant, and then there are some cases that are defined. For example, when the decision comes from high-risk AI and occurs in the event of profiling, irreversible impact that is difficult to reverse, or risk to life or physical integrity, which is what Nicolo mentioned before. So it's a lot, but basically the whole idea is that you have these two categories of rights, and they reconcile a rights-based approach of rights that are applicable to anyone that is interacting and that is affected by AI systems, and that is mostly focused on transparency, information, and then you have the let's say, stronger provisions that are relative to high risk and that is existence of relevant legal effects. And this is something that I think is very interesting from the Brazilian approach. And finally, because I know I already talked a lot, I think Laura also mentioned this, there will be a lot of work, I guess, made by the authority that still needs to be established in terms of providing more specificity, especially for the form and conditions of exercise of these rights, but they are actionable, and they are actionable not only before the administrative authority, but of course before the judicial system, because we, of course, have other rights, and it has to interact with the legal system as a whole. So yeah, I'm going to stop here because otherwise I will start commenting from like the civil society perspective, but I think this is a good overview of the rights-based approach in the AI Act. Thank you.
Thank you. Thank you very much. We have tried to give you a sort of overview of the different key aspects, I think. I would like to make some comments about one of the core elements of both the Brazilian and the EU regulation, that is impact assessment, fundamental rights impact assessment, but it's part of the next panel. So we stay and we discuss furthermore in deep in the next panel this aspect. But before open to discussion, I want to highlight one point. It seems to me that also based on the presentation emerged two aspects. The first aspect is that there are similarities between the EU AI Act and the Brazilian AI Act. The second aspect is about the fact there are differences between the EU and the Brazilian version. So what it means? It means two things, I think. The first one, that there is not a post-colonialist approach of the European Union in promoting its model outside Europe. The model was considered by the committees not because it comes from Europe, but because I have some elements that can be useful to draft a regulation on AI. And in this sense, I think this is also the important impact that the AI Act may have at global level that is not related to the Brussels effect, but is related to what? It's related to the fact that it's not the case that Brazil and Europe have decided to create a regulation on AI because they have to face the same challenges. And the same challenges are the challenges that countries that are not the master, we can say, of AI, that have a not strong AI industry, cannot directly have an influence of the big players that put a product on our markets. And so we have no way, if not to set some guardrails, some limitation in order to say that this product should be followed, not just general competition rules, but also the values that we have in our society. For these reasons, it's important that the protection of fundamental rights in this content, and is something that is present both in the parliamentary work of the European Parliament, and then fortunately endorsed in the trilogue also by the rest of the co-legislator, and is also present, much more evident, we can say, in the Brazilian experience. So in this sense, I think that there are similarities and differences, but I think that this also breach a traditional framework that is quite common many in Latin America, this idea of global north and global south. I think that we have to reconsider this approach because in many cases Europe is represented as a global north versus Brazil as a global south. But I think that the map of the digital world is a bit different. It's a map in which there are big countries in terms of power over data and power over the infrastructure of data, and other countries that have not the same power. And this is cross-cutting the traditional geographic representation of the world, we can say. So in this sense, the problem with regard to AI is between the AI developers and the AI adopters. Although both in Europe and Brazil there are initiatives in order to invest in AI, in order to carry out research on AI, we have to recognize that our market, both our market are not enough mature in terms of competition. And I think that it's also important that in both this regulation there is a close reference, specific reference to fundamental rights, because something that is emerging in Europe, but I think also in Latin America, is that regulating technology is not just a market regulation problem. It's true that EU focus on market regulation by definition, but it is much more than the market. We have to raise concern about the fact that some technologies that are used in our countries are technologies that are based on the exploitation of the people, based on the exploitation of the world and the environment, have a negative impact on many rights, create a discrimination and potentially affect many rights. So this is a condition in order to operate on our market. So in this sense, we have to raise the concern about the role of human rights more in general with regard to digital innovation, because this nice idea of move fast and break things that unfortunately we thought was past and represented a past negative experience of the Californians guys, now is back again. Because if you look at what's managed, that's ChatGPT and similar experience, the idea is clear. We make business. We won't have a lot of money. We don't care about the protection of personal data. We don't care about the copyright. We don't care about the negative consequences on this system that are put on the market and may affect many aspects of social life, including with severe impact on fundamental rights. So for this reason, it is important that the different kind of culture from Europe and Brazil and more in general Latin America react to this kind of approach, because we want innovation too, but we want innovation that is responsible. We want innovation that follows the citizen values and the country's value. We don't want innovation coming from China or Russia that replicate, or US, sorry, Russia, or US that replicates some values and some way of seeing the society. For instance, for a conference last week in Italy, I asked to co-pilot in Bing a street in Africa, street in Europe, a street in America. The street in Africa was a dust road. The street in America was a street with a US flagship. And the street in Europe was a street that was in the middle, strange idea, between the Mediterranean approach and the Nordic approach. So Mediterranean paths with Nordic buildings. So this is the stereotyping of our society that reflects something that is not consistent with our value, with our representation. So we have to raise the voice in order to accept and foster innovation, but an innovation that is in line with our value. And I think that AI regulation is the instrument that we have in order to that. For this reason, we can learn each other. For instance, there are some aspects also regarding the impact assessment in the Brazilian proposal that are much better than some confused provision after the trilogue in the final version of the AI Act. But this was just a comment. I don't want to benefit more from my position of moderator. So I prefer, consider also the time, to give the floor to the audience. If you have any question about AI regulation, the interplay between AI and data protection, we'll be happy to discuss with you this topic. So please, if you have a question, we have a mic somewhere. Yeah, thank you.
While we are collecting the question, may I make a very short comment?
No, of course.
Because you refer to innovation, I think it's relevant to mention that there is a complementary part to the regulation of AI, which is the, what they call fomentation, so incentive to innovation in AI. And so in Brazil, in parallel to that bill, the principological bill that was mentioned at the beginning, there was an AI strategy that was developed, but it was basically a series of rhetorical arguments. You know, we need ethics, we need innovation, SMEs, and so on, but there was no clear vision. So I want to put a plug to a panel that we are doing on Thursday afternoon, which is AI needs a strategy, not just a regulation, comparing approaches in Latin America, where we're trying to show what is being done. And in the European Union, I think the AI Act also has that component a little bit more, because it's more comprehensive. So that's something to be developed. And one of the aspects is sandboxes was mentioned. For example, there is only one obligatory sandbox in the AI bill of Brazil, which is the copyright one. The other ones, so they can be developed, but there is no obligation. Whereas in the European Union, since it's a federal system, they ask that the national authorities establish a sandbox for AI, and they go much more in detail regarding the criteria and so on. So this is something that we should also develop further. That's my comment.
Question? There. There. Sorry. Okay.
Yeah, my name is Ingrid Schneider from University of Hamburg. I would like to know a little bit more about the possible enforcement of the AI bill and whether the ANPD will be extended in terms of its authority and competences, and how is the interaction between data protection, consumer protection, competition law, and AI regulation.
Let's collect a few questions and then we reply. You manage.
Hello, my name is Maria Villegas Bravo. I'm with the Electronic Privacy Information Center, or EPIC, in the United States. My question is, in the US, a lot of the discussion around AI and labeling synthetic content is right now on watermarking and different kinds of labeling. I was wondering what the conversation looks like in Brazil on the right to know that you're interacting with an AI system before it happens, and how, if there's been any more like granular discussion on how that would happen. Thank you.
Hi, my name is Ansgar Kuhne with EY. As we're moving in the EU now towards having the Act coming into legislation and looking at the implementation phase, a big question is around where is the skills, both in the regulators and in organizations, to be able to actually do the oversight and make sure that compliance is effectively reached. Is there any thinking around building out those kinds of skills happening in Brazil in that kind of respect?
Thank you for the talk. I was just wondering, I think Mr. Zingares mentioned that in the draft act of the AI law in Brazil, it was stated something about that the economic power of providers also relevant in assessing the impact of AI systems. And actually, Mr. Montenegro also mentioned the move fast, break things dynamics coming back in the field of AI. And I was actually wondering, taking into account the AI Act in Brazil, how does the Act deem that this economic power should be considered in the assessing of the risks? And would you feel that's an effective way of approaching it?
Hi, I'm Farid Masouli from Radboud University. I have a question for all of you. You mentioned, now it's the AI Act, but I wanted to know how it is in Brazil in terms of sectoral applications, because we have a set of European horizontal legislation in Europe, but then we have all the data spaces that are about to be unveiled. I wanted to know how it is in Brazil, and how does the Brazilian AI Act already lays the ground for that eventually, when there would be overlaps with sectoral legislations.
We have a last question there. Karen?
Yes. Hi, Karen Cohn from the Center for AI and Digital Policy Europe, CPDP Europe. I would have two, if possible, we'll see. First, for Maria Vima, with regard to data protection, do you have some enforcement actions or collaboration with the RED network, the Ibero-American network of data protection authorities? Because, for example, in Colombia, in the framework of this network, it seems there were some actions against OpenAI ChatGPT. But do you have other actions coming up, or also policy planning with regard to how data protection authorities in Latin America are dealing with AI? And the second question was about what Alessandro Mantelero said, which is, could you please explain a little bit more what are the difference between impact assessment in the EU Act and the Brazilian approach so far? That would be interesting. Thank you very much.
Okay, so we have a lot of questions. I suggest to my colleagues to address the question that you prefer. Hopefully not all the questions, because if not, we have a panel for the next 2 hours. So take the question that is more consistent with your topic, or that was specifically addressed to you, and so we can manage to stay in the next 15 minutes.
Okay, I think I'd like to take the question on the interplay of AI regulation with both sector-specific legislation, but also cross-cutting rules on competition, consumer protection, and competition and data protection. So I think this is indeed a huge challenge, but it's not something new that we're facing in Brazil or elsewhere. And I can comment that in Brazil, as we were discussing the approval of the General Data Protection Law, we had a very similar discussion. So I recall in the early days of the legislation, Laura may remember this, practically all sectors proposed that the data protection law should not apply to them. This law is fine as long as it does not apply to IoT or healthcare or financial services, because each sector considers itself to be very unique and very special. And at that time also there was a concern that there would be some level of overlapping or competition between different regulatory authorities. This is in fact a challenge, but the way we have faced it in Brazil is defining that the DPA actively has a strategy of engaging with other regulators. So this is in fact part of our strategic planning, and we have established cooperation agreements with a number of different agencies and authorities, such as the National Consumer Secretariat, the Competition Authority, the Supreme Electoral Court, our Transparency Ministry, and also other sector-specific agencies. And the idea here is that the Data Protection Authority will not reduce the scope of competencies of sector-specific agencies, but in fact be able to complement them, in the sense that there are consultation mechanisms, there is the possibility of exchanging information, and we even have a case in Brazil where we have had joint enforcement actions involving ANPD, the Consumer Secretariat, the National Antitrust Body, and public prosecutors. So I think this is still work in progress, and I feel that as we discuss AI legislation, the dilemma we face is very similar. because in fact it's not feasible to imagine that one single central authority will be able to have expertise in all fields. On the other hand, if we have absolute fragmentation, this will also bring legal uncertainty, since every agency will interpret the law according to its own criteria and not necessarily according to a harmonized view of fundamental rights. So I think the challenge, in fact, is to establish these formal and informal mechanisms of institutional cooperation in order to bring more stability. The other point that I think I'd like to comment upon is the issue of skills of regulators and organizations. In fact, this is also, I think, very challenging. And again, we faced the exact same problem when the National Data Protection Authority was created. So our DPA was created from scratch. There was previously no legislation specifically on data protection, and in fact, we didn't have a huge pool of experts within government to actually help build up the DPA. So this is ongoing work. We have, of course, capacity building initiatives. We have a multidisciplinary group of staff members that come from different organizations and agencies. So people with different backgrounds and also different experiences in regulatory bodies or in ministries. And I think this sort of helps set the stage to deal with a technology that is also very transversal and that requires this diverse and multidisciplinary outlook. But in fact, I do appreciate and fully agree the challenge that this is.
Thank you. Yeah, of course. Thank you so much for the questions. So maybe on this idea to how should the authorities coordinate, I think the idea of a system that is in the bill right now is exactly to try to facilitate this coordination. Of course, we have also to differentiate, to separate the competencies of each of these bodies, and I think that's the discussion right now. One possibility, one of the ideas that is already in the bill is to say that the coordinator has a much more fundamental rights orientation as to the agencies, the regulatory agencies that are much more looking for the market and for the technicalities and specialities of each market. So the idea is to separate competencies also in order to allow them to cooperate in many instances. So I think that's one of the ideas. Regarding also skills and also the question regarding economic power, I would say that not all the questions could be or are going to be answered by the regulation, but as Nicolo already said, we are discussing, or the government is discussing right now, a plan on AI that should be more concrete than our strategy that is also being reviewed right now. So what I saw about this plan is to discuss, or it should comprehend capacity buildings. It should comprehend also comprehend also a more pro-competitive approach in order also to address the question of economic power. So I see that the idea is to have not only the regulation side, but also this AI plan to tackle and to address other issues that are not being tackled in the AI regulation bill.
Thank you. Mariana.
Thank you. I will address very briefly the question about synthetic content, just pointing out to Article 19 of the current draft, the current bill. It provides for, let me just get the exact text here, but just 1 second. I had it. Yeah, it basically says that when the artificial intelligence system generates synthetic content, it has to include considering the state of the art of the technological development, an identifier in such content to verify authenticity or the characteristics of where it comes from, any modifications or modes of transmission. So basically, I think the law, the proposal captured some of the discussions that are also taking place elsewhere. And it also, of course, provides and mentions that this specific provision does not make up for the other requisites in terms of information and transparency. So you have to look at the whole system to understand all of the provisions regarding transparency and the right to information. And also, I think about skills. Everyone wants to say something about that, but as someone representing a civil society organization, I think civil society has a very important role to play in that. So we, of course, have been working on capacity building, on data protection, training, and AI for many years. And I think one of the challenges, even beyond lack of resources, of course, is that when it comes to AI, in order for civil society to be effective, it has to work in coalition, and not only between organizations that are already very well versed in digital rights, but also with organizations that are working in other areas that are impacted by AI, such as labor, such as the environment, such as women's rights organizations. And this is really difficult to accomplish when you also have to take into account the very short deadlines to contribute and the technical aspects of the text that is ever changing. So I think this is one additional challenge for civil society, but at the same time, I think there is a very important role to be played by civil society, and that this role should also be strengthened in the current proposal. This is something that we are defending, that the role of civil society should be enhanced also in the proposal. Thank you.
Thank you. Niccolo.
So I think what remained for me was the specific question on the economic power. That's a very interesting question. I mean, there is no further elaboration on what they would mean as economic power, but I think it's interesting to tie this to the open source concept. So to some extent, the availability of open source tools, or foundation models, can further competition, So there is no specific exception in the Brazilian bill for open source, like the Brazilian version, the European version. It's interesting to see that there was an exception in the fake news bill with regard to platforms that are devoted to sharing open source software, but there's nothing here. So this can be an element to interpret economic power. I think it will create a bridge with competition analysis. There are several questions about how competition authorities should define power in AI, because it's a value chain. You need to take into account not only the software, but also the computational capacity, the skills, and so it's reducing to just use the concept of open source. Even within the open source literature, there's a big question of what it means to be open source. You need to release not only the code, but also the data that are being used for the training, the models, the code that has been used for training the model, the biases. So there's a series of things. And sometimes there is this claim that something is open source, where it's really not that quite open source. There's a very nice paper by Meredith Whittaker that is called Open for Business, and it shows that some of these claims are grossly exaggerated, and they're against the spirit of open source. And one aspect I think that is important is that open source is not just a term I also used yesterday, release and forget. You need to have maintainers of open source, so you need the collaboration in the value chain. So if you are just releasing the code and you're not helping the deployers to understand how to make use of it, that's not quite enough. So I think this element will definitely play a role in interpreting economic power.
Thank you. Just before the gong, just a quick comment about skills. I think that as regards skills, it's not just civil society, but there is a huge effort also. Okay.
Just in time.
This is a tradition, a local tradition. We suffer a bit if you are not local about this tradition. But the skill is not just a civil society that is very active, also in Brazil, but it's also one of the main tasks of university. All the universities are investing more in AI, not just in AI and computer science, they already have this kind of program, but in between the social and the technological perspective of AI development. And so I think this is an important role for the academia and for the university. And with regard to Red Iberoamericana that was mentioned, I think it's a matter of geopolitical relationship because the Red Iberoamericana is pushed by Spain and is more focused on Spanish-speaking countries. So I think has not a lot of influence in Brazil. But we can say that also all this fragmentation is not so positive. We have to collaborate more also between the different actors in Latin America because at the end the same question, same issues are discussed also in the Red Iberoamericana with regard to AI, like at global level in GPI, etc. So I think a better collaboration is in mutual interest. And finally, impact assessment is something that discussed in the next panel, but just to give an input also for the next panel, if you want to stay, is I think there is a big difference. Both the acts have a reference to fundamental rights, to impact assessment. The difference, from my perspective, is that in Brazil there is more concern about the impact on fundamental rights, more concern about the methodology, etc. It's true that in the Brazilian Act there is not a specific reference to fundamental rights impact assessment, it's impact assessment in general. But if you look at the AI Act, there is fundamental rights impact assessment, but the Article 27 was made worse during the trilogue, and there is a clear view from EU regulator, we can say, that it's just a matter of standards or something like that. So I think that in terms of maturity of the debate in Europe, it's not so mature, there's not enough awareness about the fact that the fundamental rights impact assessment is not just a matter of standards, it's not just fixing the problem of safety or security of a car, but it's a bit more complicated. So in this sense, I think that we can learn a bit also from the more nuanced perspective of the Brazil. So we stop for now, we have the break, and then we have another panel on the same topic, because, of course, CPDP realized that it's quite important, this kind of discussion between Europe and Brazil. So see you later. Thank you.